Hello, my name is Rachel Perry, and I am a staff lawyer at Luke's Place. Today I'm going to talk to you about how intimate partner violence and the family law system intersect. We will look at what family court can do in situations of IPV and the challenges survivors face in family court. Before we look at how IPV fits into family court, it's important to understand what family court is designed to do. Family court does not determine guilt or innocence. That is the responsibility of criminal court. Instead, family court helps families make decisions about how a family will function after a relationship ends. Family court deals with things like parenting arrangements, which include who will make major decisions for a child and how much time a child will spend with each of their parents. Financial support, division of property, divorce for people who are married, restraining orders, and child protection. Many of the women we support at Luke's Place are focused on getting family court orders that will help keep themselves and their children safe. Today, I'm going to talk about how intimate partner violence is considered by the courts when making decisions about parenting after separation and protective orders, such as restraining orders and giving one person exclusive possession of the home. So let's start with parenting orders. Judges make decisions about parenting based on what they believe is in the child's best interests. These decisions are not about what the parents want. Instead, they focus on what will best support the child's physical, emotional, and mental safety, security, and well-being. The law gives judges a list of factors to consider when deciding what is best for the child. One of these factors is family violence, which includes IPV. This is important because children can be seriously harmed by violence, even if they are not the direct target. Just seeing one parent being violent towards the other can cause lasting damage. Judges need to consider whether violence is present so they can make orders that protect children from further harm. The law defines family violence broadly. It includes both physical and non-physical forms of harm, such as emotional abuse, financial abuse, threats to kill or hurt someone, and harassment. It also includes coercive control, which is when someone tries to dominate or control another person in harmful ways that profoundly impact a survivor's autonomy and sense of self-worth. Family courts can treat something as family violence even if it is not a crime. When there is family violence, a judge can make parenting orders to keep everyone safe. These orders can include: one parent makes all big decisions. The parent who is subjected to violence can be given full control over major decisions for the child, meaning they don't have to ask the abusive parent first. This is called sole decision-making in family court. Less parenting time for the abusive parent. The judge can limit how often the abusive parent sees the child. Sometimes, visits must be supervised by another adult at a supervised access center. Safe drop-offs and pickups. The judge can order that someone supervises when the child moves from one parent to the other so the survivor and child stay safe. Limited communication. The judge can make rules about how parents talk to each other. For example, they might only be allowed to use a parenting app and only talk about certain topics at certain times. Family court can do more than just make parenting rules to keep survivors and children safe. One important tool is a restraining order. A restraining order can stop the abusive person from contacting or talking to the survivor and keep the child away from the survivor's home, work, or other places like the child's school. Restraining orders help protect survivors and children physically and emotionally. If the abusive person breaks the rules in the restraining order, they can be charged with a crime. You can ask the family court for a restraining order against someone you are married to or used to be married to, someone you lived with, even for a short time, or someone you share a child with. Restraining orders can last for a short time or be permanent. Another tool available in family court to help keep people safe is exclusive possession of the matrimonial home. This order lets the survivor and children stay in the home while the abusive partner has to leave. You can ask for this order even if both names are on the lease or deed. An order for exclusive possession doesn't change who owns the home. It only decides who can live there while the court case is happening. These orders can make life safer and more stable for the survivor and her children after a separation. Finding a new place to live that is affordable can be very hard, especially for someone with kids. Only married people can get this type of order. Before a judge makes the decision, they look at things like whether one spouse has been violent towards the other, the financial situation of both people, and whether it would be best for the kids if they could remain in the home with one of their parents. Even though there are legal tools to help in family court, survivors often face big obstacles when trying to use them. The family law system is hard to understand and often not accessible for people from different cultures or languages. Survivors are usually dealing with trauma, money problems, and ongoing threats to their safety. At the same time, they are expected to write court documents, gather evidence, attend hearings, and make tough decisions about their children and finances. Family court doesn't work alone. It connects with many other systems. Survivors often feel pulled in different directions with little coordination. While going through family court, they may also be looking for safe housing, trying to secure income, managing immigration issues, caring for children affected by violence, dealing with child protection services, and coping with criminal charges against the abusive partner. All of these challenges make it harder for survivors to fully participate in family court. Many judges, lawyers, and court staff do not fully understand IPV. They may believe harmful myths, such as the violence stopped when she left, she's exaggerating to gain an advantage, she's turning the child against him, and if it was that bad, she would have left sooner. These myths can hurt survivors. Abusive ex-partners often use them to make the survivor look dishonest or unreasonable. This can lead to judges denying protective orders that would keep the survivor and children safe. Family court is not trauma-informed, meaning that the system does not identify and address trauma properly and often causes more trauma to survivors. Trauma can cause survivors to seem anxious, upset, or distracted. Judges may misread these signs as unreliability instead of understanding they are effects of abuse. Proving IPV is also very hard. Abuse often happens in private, so there may be no evidence beyond the survivor's own story. Survivors are often asked to show a pattern of abuse, but many judges struggle to see how the violence affects every part of the survivor's and child's life. Without proof, judges may refuse protective orders. Many survivors go to family court without a lawyer. About half of women are unrepresented, and in big cities, that number can be as high as 80%. Without a lawyer, survivors may be pressured into unsafe agreements or give up their case because they fear not being believed or having to face their abuser. When survivors don't have lawyers, they are more vulnerable to legal bullying, which is a form of abuse where the abusive ex-partner uses the court process to maintain control. This can include bringing unnecessary issues back to court, delaying proceedings, refusing to share documents, changing lawyers repeatedly, and/or making false accusations. The goal is to intimidate the survivor and wear her down until she gives up or accepts an unsafe settlement. Family court is complicated, and survivors face many challenges. That's why it's important to have help from professionals who understand coercive control, violence after separation, risk factors for serious harm, legal bullying, trauma responses, safety planning, and what court orders are available to promote safety. Without this kind of support, survivors may be pressured into unsafe agreements, discouraged from speaking up about safety, or even blamed for the abuse. Trusted advocates, supportive friends and family, and professionals all play a crucial role in helping survivors navigate the family law process safely. One type of professional I want to highlight is family court support workers. Family court support workers are trained to help survivors navigate family court. They often work in shelters or women's centers across Ontario. They can help by helping to create safety plans, explaining family law and court processes, providing emotional support at court and during family lawyer meetings, helping survivors prepare for lawyer appointments and follow up afterward, gathering evidence and organizing the story of abuse, and connecting survivors to local services and advocating with those services. Working with a family court support worker also helps other professionals and allies understand the challenges survivors face and learn about local resources. Luke's Place has its own team of family court support workers that provide support to women in Durham Region. The Ontario government website lists other organizations across Ontario that also provide these critical services. Many survivors cannot afford a lawyer. Legal Aid Ontario may cover the cost for those who qualify based on income. Legal Aid offers certificates for family law lawyers, which means that Legal Aid will pay for your lawyer, 2-hour legal advice certificates for survivors of domestic violence, which are available to all survivors regardless of income and are distributed through shelters and legal clinics across the province, and duty counsel and advice counsel at courthouses for emergency situations or legal advice on the day of a court hearing. More details about these services are available on the Legal Aid Ontario website. In addition to having a team of family court support workers, Luke's Place provides other free legal support services to survivors of IPV across Ontario, including a legal clinic offering family law legal advice, help with drafting court documents, and written resources and virtual workshops on topics like managing a legal bully, completing court documents, and gathering evidence of abuse. Visit lukesplace.ca for more information about all of our programs and services. We also offer Family Court and Beyond, a free workbook on family court and safety planning, available in English and French at familycourtandbeyond.ca. Family court was not designed with intimate partner violence in mind. Survivors often face a system that doesn't fully understand their experiences or safety needs. By learning about these challenges, friends, family, and community members can better support survivors and help them connect to resources. Thank you for watching this webinar. Please check out our other webinars, specifically the webinar called Being an Ally, Community Resources for Supporting Survivors, which gives you some tips about how you can support someone in your community who is being subjected to IPV and is in family court, or thinking about starting a family court case.